Hello, everybody. I'm going to try to do this. Let's see if I have any better luck than Seth had. How's that? Can you guys see the Chaco Canyon slide? Good. Okay. All right. Thank you. This is our first webinar. You guys are in on the ground floor of the CILJ, so congratulations and thank you. Thanks for being part of helping us move forward. And we did practice this, but it was kind of rushed and challenged. So good to see everybody. Glad you're here. So, as Seth said, I'm going to talk about the Renaissance in tribal governments and then a little bit about jurisdictional conflicts that are arising more and more and more as tribes exercise more power. So, let me see if I can get my slide to advance. There we go, the tribal Renaissance. Let me talk a little bit about the tribal Renaissance. It did advance. You see the powwow, right? Yeah, okay, good. All right. So there are sort of two main things that have happened over the last 50 years that have really advanced tribes. And by the way, this is not a story against Republican administrations at all. In fact, it's quite the opposite. It's been Republican administrations that have really, helped move tribes forward. One of them is because of the tribal advances from the Indian Self-Determination Act that was passed in 1975. And that was a Richard Nixon initiative that he really got behind. And it allowed tribes to take over the Indian Health Service activities and the Bureau of Indian Affairs activities. And it expanded over time, expanded quite a bit during the course of the last 50 years or so. This is the 50th anniversary this year of that law. And tribes have more and more and more taken over those activities. And today, tribes run more of those programs than either the BIA or the IHS, at least if you measure by dollars. Most of the money, more of the money of both of those agencies are going out to tribes for tribes to run the programs than are retained by the agencies to run those programs. So that's a big deal. It's not been easy. Tribes have litigated against the federal government numerous times, and they've gotten numerous tweaks to the legislation over the years. But they've gotten to a place where they've reached quite an outstanding place. This is my own. I'm Chickasaw. Grew up in Oklahoma. I used to say that I grew up on the former reservation boundaries of the Chickasaw Nation, but now I can say I grew up within the Chickasaw Nation, which we learned after the McGirt case. But this is a picture of our tribal health facility that our tribe built. This is IHS helps fund the salaries of the people that work in this building, but my tribe built the hospital, and it's a beautiful place, and it's got valet parking, and it's pretty fancy. It's much nicer than the facilities that I grew up going to in the Indian Health Service in Talahina and Ada, Oklahoma, and other places. So it's been a quite advancement for tribal sovereignty. I will tell you, it was not easy at the tribal level either, because my tribal governor, it's the same governor now who really started to institute these programs at the Chickasaw Nation. His name is Bill Anatubby. And when Governor Anatubby said that he was going to take over the Carl Albert Indian Hospital in Ada, Oklahoma, I remember my aunts and uncles complaining about that, saying, we can't run that hospital better than the federal government can. The governor's crazy in doing this. And politically, it would have gone very bad for him. It might have gone very bad for him, but right away, service improved to Indian people, to the Chickasaw people. And so Chickasaws really got behind it. And Governor Anatubby believed in the Chickasaw people before they believed in themselves. That's, I think, why we've been so loyal to him. He's still our governor, probably 35 years after he, started taking over these programs. So that's been a big deal. That's been one of the big developments. You probably know the other one. The other one is Indian gaming. This is the Tejon Indian Casino that just opened about a week ago, I believe. And it's one of the biggest, it's a huge casino. It's, sort of Las Vegas size casino, and Tejon just opened it. So, part of the lesson there is it's still growing, right? I mean, the gaming is still growing. And this one was done in partnership with the Hard Rock Casino empire, which is owned by the Seminole tribe of Florida. So you've got a California tribe being supported by a Florida tribe in opening its casino. And I'm sure all of you know that the revenues from Indian gaming are not spread evenly across Indian country at all. That said, they've been out, they've contributed in an amazing way to resources for a lot of tribal governments. And every summer, the federal regulator of Indian gaming, the National Indian Gaming Commission, issues its revenue numbers. And if you add up all of the audit numbers for the fiscal years ending in 2024, that's what the NIGC does. They add all, tribes have different fiscal years. So the timing, we're not comparing everything in the exact same time frame because tribes have different fiscal years. But for each fiscal year that ended in 2024, the NIGC added up those numbers and issued the overall number in the summer of 2025. And this past summer, what the NIGC said was Indian gaming brought in about $44 billion into Indian country through gaming. And just to give you some perspective, the combined budgets of the BIA and the IHS is probably about $11 billion. This past fiscal year. So Indian gaming brought in about 4 times the money that the BIA and the IHS spent in Indian country, either through tribal programs or their own federal programs. So Indian gaming has had a dramatic impact, as you can imagine. That's the sort of the bottom line here. So today, about 4 times more money comes on Indian reservations from Indian gaming than from BIA and IHS and BIE all put together. And by the way, this was also born a brainchild really of a Republican administration. Tribes started gaming modestly in the 1970s, but it really gained steam in the 1980s during the Reagan administration. And Ronald Reagan said, I see this as a great economic development opportunity for tribes. And his administration really started encouraging tribes to engage in high stakes bingo, and that developed into the Indian gaming industry, and it brought us the Cabazon ban decision out of the Supreme Court, which confirmed that it was legal. And Congress enacted the Indian Gaming Regulatory Act soon thereafter to create a regulatory structure. So it's, again, and that was the federal government was supporting that effort, not fighting that effort, which is an important lesson. Now, what have tribes done with those resources? They've done all sorts of things with those resources, and and many of them have improved the lives of tribal members, and they've used those monies to really expand the boundaries of tribal sovereignty, and certainly to continue providing the services that the BIA and the IHS provided Indian tribes, but also to expand those services. And it's given tribes much more flexibility in doing that. So let's talk about one of the areas where they've really expanded what they're doing in Indian country. This is just a list of the Supreme Court cases that were involving federal Indian law and criminal justice or criminal jurisdiction in the last 10 years. There have been, 7 or 8 U.S. Supreme Court decisions that are right around the subject of criminal justice or criminal jurisdiction. And that's a sign that one of the things that the tribes have been doing with their resources and as part of this renaissance is exercising much more criminal justice authority. We all know about the problem of missing and murdered Indigenous people, and tribes, have really been putting their efforts, where their mouths are in complaining about that issue, and they've been doing a lot more. And so just, looking back at these cases shows that the tribes have been working really, really hard to address problems. Nebraska v. Parker, for example, was the Omaha Indian tribe trying to exercise its liquor ordinance in a community in Nebraska that said that we're out, you can't do that. We're outside the reservation. And the tribe said, no, you're inside the reservation. And it got litigated all the way to the Supreme Court. Similar issue was litigated up to the Nebraska Supreme Court involving White Clay, Nebraska, where people were selling liquor onto reservations, mostly in South Dakota. But this issue has been reaching the Supreme Court quite often because tribes have been very aggressive in exercising their powers. It's not just, though, in the Supreme Court where we're seeing that. We're also seeing criminal justice advancements from both the White House and from Congress. And some of those examples are the Tribal Law and Order Act of 2010, the two Violence Against Women Act reauthorizations. That's a bill that needs to be reauthorized for funding purposes about every 5 years. It doesn't always happen on time, but there's always there's often a VAWA reauthorization coming down the pike because it's an opportunity to adjust things, and there's been some of that happening. So again, tribes started addressing this in the early part of the century, and the MMIP problem was existing back then, and violence on Indian reservations was high, particularly domestic violence. So one of the things that tribes lobbied for was the Tribal Law and Order Act of 2010. And one of the things this one did is to restore the ability of tribes to prosecute felonies, because what was happening before the Tribal Law and Order Act of 2010 was passed was tribes could prosecute murder if they wished, but they were limited to a 1-year sentence. And so it wasn't a very effective way to prosecute major crimes. And otherwise, they had to wait for the federal government to take action. So the Tribal Law and Order Act did a whole bunch of things. There was a laundry list of things that it did. It also made efforts to include tribes within sort of the community of law enforcement in the United States by giving them more access to data, law enforcement data, and that sort of thing. But one of the things it did was expand the ability of tribes to prosecute felonies. So that was one of the big developments, and a lot of tribes have taken up that authority. Not all tribes have, but a lot of tribes have. The Violence Against Women authorization of 2013 contained what we call an Oliphant fix. Oliphant was the 1978 decision that said that tribes don't have jurisdiction over non-Indians within their reservations. That created a problem, really a prosecution-free zone, particularly for domestic violence offenders. And that was I think that if non-Indians could move onto reservations, date or live with Indian women and then beat them with impunity, because tribes didn't have jurisdiction over non-Indians. States don't tend to be patrolling on all reservations very aggressively, and so it had become a real problem. And so the Violence Against Women Act of 2013 allowed tribes to prosecute some offenses against non-Indians, particularly around domestic violence or acquaintance rape type situations. The theory, by the way, for the limitations was that someone who knows that they're in a relationship with a Native American woman has sort of consented to tribal jurisdiction. That was kind of the theory, but that was a limiting principle, sort of what the tribe's authority was. But it was a good day. It was when that bill was signed, it really gave tribes another important tool to address one of the most serious causes of the MMIP problem, or MMIW problem for sure. So that went well, and so in 2022, Congress lifted that limitation about sort of the offender knowing the victim or being in a relationship with the victim. The great step forward for the VAWA reauthorization in 2022 was tribes could prosecute even stranger rape, people who committed crimes on their Indian reservations, even if they didn't know their victim. And again, a great step forward, because it gives tribes much more ability to exercise self-determination and self-governance over these very serious problems of violence on Indian reservations, even if there are non-Indians involved. And that's important. One of the challenge of that Oliphant case, the 1978 case that said that tribes can't exercise jurisdiction over non-Indians, is it arose on a reservation, the Suquamish Indian Reservation, that only had about 50 tribal members living on the reservation and 3,000 non-Indians. And so one of the reasons that scholars and Native advocates were outraged about the Oliphant decision was, the demographics were just really highly unusual. And yet the Supreme Court issued a decision that would theoretically apply to the Navajo Nation, which has kind of reverse demographics. Probably, I don't know the exact numbers, but when you go to Navajo, it feels like 90% of the people in Navajo are Navajo or Native American, and only a very small number are non-Indian. And yet that Oliphant ruling applied to them. So VAWA 2013 and VAWA 2022 really sort of sorted that out to some degree to give tribes much more authority to exercise jurisdiction if they wished to undertake it over non-Indians. Came with some limitations. They have to provide quite a bit of due process. One piece of the due process that's kind of interesting is that tribes have to provide representative juries. In other words, if a tribe prosecutes a non-Indian, there needs to be non-Indians on the jury, which is kind of ironic because I was a federal prosecutor in the 1990s, and I never had a Native American on a jury when I was prosecuting Native Americans under the federal criminal laws. And so, what the lesson here is tribes have to provide far more fair juries than what the federal government has typically provided over the centuries and the decades when they prosecute these kinds of offenses. I'm not complaining about that because tribes ought to be fair, but I think that there's a bit of an irony there. So tribes can now prosecute just a lot more than they ever could before, and that's given them just much more power. One real measure of sovereignty is whether you have the authority to throw people in jail. And if you have people the authority to throw people in jail that are not your own citizens, that's a really, that is sovereignty. That is true sovereignty, and it might be the most significant exercise of sovereignty when you're taking somebody's liberty away, and tribes now have the ability to do that. So that's been a major step forward for tribes. Those were bills passed by Congress. There's also been some real efforts by the executive branch to restore tribal authority or center tribes in the provision of criminal law and justice in Indian country. And that's in part through retrocessions in so-called public law 280 states in which states are accustomed to exercising jurisdiction on Indian reservations. This picture is from the Yakama Nation reservation, which jurisdiction was retroceded to Yakama and the federal government in Washington state from the state of Washington in 2015, and really kind of taken up in 2016. And this was a celebration of that. But in 2018, Congress also retroceded, and President Trump signed the bill, the jurisdiction over the Meskwaki settlement in Iowa. It's a tiny little community in one of the counties in Iowa. But this was, again, a story about Republicans supporting tribes. This was a bill by Charles Grassley and Joni Ernst, two Republican senators in Iowa, and passed through Congress, and a Republican Congress, and was signed by Donald Trump. And it restored Meskwaki and federal jurisdiction over the Meskwaki settlement, which is what the Meskwaki folks call their community, their reservation in Iowa. So, even recently, since Trump has taken office, he has, indicated that he is committed to, criminal justice issues in Indian country. And so It's not been a central focus, but they announced this Operation Not Forgotten um, program soon after Trump took office, in which they were trying to surge FBI agents into Indian country, so they could, they've been sort of claiming that there's a lot of crime in a lot of places, which is usually an exaggeration. I think crime is down really around the country. But Indian country has not been spared the benefits of greater law enforcement by the Trump administration. So, the bottom line is tribes are exercising more authority here. They're doing it with the support of the federal government, which is good because, whereas, when we think of going forward with conflicts with states, tribes are far stronger when they've got the federal government in their corner or some sort of federal legitimization of their power. And and they've had that. They've had a real history of that. Just to talk a little bit more, each of these cases that I mentioned previously, it's this was a unanimous decision in 2016 that held that the village of Pender of Nebraska was part of the Omaha Reservation. And the implication of that was that the tribe could exercise its alcoholic beverage ordinance in the village of Pender, even though there weren't very many there were not very many Omaha members living in the village of Pender. It was a largely non-Indian community in which the land was not held in trust, but it was within the reservation boundaries. Another one of these decisions, another unanimous decision, was United States v. Bryant. And here there was an offender who had prior tribal court convictions in which he was not represented by counsel because it wasn't required in tribal courts. But he was prosecuted for a subsequent federal prosecution because he had a long record. And the question was whether those tribal court convictions could be used as predicates for a repeat offender in the federal court. And the US Supreme Court unanimously said, yes, it's okay to use tribal court convictions. That's a good thing. That's the Supreme Court saying tribal court convictions are valid and allowing them to be relied on, even in a matter as important as taking away someone's liberty. So that was a big deal. McGirt has been the most interesting development in Indian country in the past, in the past 10 years, probably. And this was, the one that had such an impact on my reservation. The famous opening line was, "On the far end of the Trail of Tears was a promise," and I think everybody got, a lump in their throat when they read that first line, and Native Americans anyway, when they read this opinion. But just to give you a sense of the outcome of this opinion, my own tribe, the Chickasaw Nation of Oklahoma, went from prosecuting about 75 misdemeanors a year to 50 misdemeanors a week soon after it became clear that the Chickasaw Nation reservation still existed. And so this has been, and other tribes in Oklahoma have similar stories. And so we have a lot more tribal engagement in criminal justice in Indian country nowadays because of the McGirt decision. And it's been disruptive in some ways because the state has not been happy about learning that this is a area of significant tribal power, but it's had real impact. Another important case, another unanimous decision by the Supreme Court said that a tribal police officer has absolute authority to detain a non-tribal member traveling on a public right-of-way, a state highway, running through a reservation for potential violations of state or federal law. In this case, the tribal officer rolled up on a car sitting on the shoulder of the highway, a state highway, and walked up, to look in, and it was pretty apparently a non-Indian, but there was an assault rifle on the front seat of the car, and tribal police officer made an arrest and discovered there was also drugs and drug paraphernalia, and called in the appropriate law enforcement sort of to take it from there. But the Supreme Court held that everything that the tribal police officer did was proper, and the tribal police officer had absolute authority, at least temporarily, to detain and arrest someone suspected of committing a crime until law enforcement with greater jurisdiction arrived. So that, again, unanimous decision supporting tribal authority. Here's another decision. This one was really spawned by the McGirt decision, but Oklahoma has, again, not been happy about tribes exercising jurisdiction in Indian country. And in this case, Oklahoma v. Castro Huerta, the question was whether Oklahoma could prosecute a non-Indian, but in the situation where they committed a crime against an Indian. And we had long, for more than 100 years, thought that such cases were exclusive federal jurisdiction. And the question was, could the state also prosecute a non-Indian in that circumstance? And the Supreme Court, in a close decision, upheld the right of Oklahoma to prosecute a non-Indian who commits a crime in Indian country, even if that non-Indian commits a crime against an Indian. And that was a somewhat of an intrusion into the idea that this is an exclusive area of federal and tribal authority. There's no Native American will ever be prosecuted under Oklahoma v. Castro Huerta, but they might be called in to be a witness in a state court or something like that. So it does potentially interfere with the idea that a reservation is a sanctuary from state authority for Native Americans, because of Oklahoma v. Castro Huerta, it may be that a state can actually at least subpoena a witness if they're Native American in Indian country or something like that. So again, the potential for Oklahoma v. Castro Huerta is somewhat troubling, in that it may be that a Native American on a reservation may not be quite as protected from state authority as they were before, but they can't be prosecuted by the state. That's not what Oklahoma versus Castro Huerta says. So it is an intrusion into tribal authority, but a limited one. Another criminal case in which the Supreme Court protected tribal authority is a double jeopardy case. This person, Dinespi, was prosecuted in a CFR court, which is a federally created court that implements tribal law. And then he was later prosecuted for the same behavior in the federal courts. And the question is, does that violate double jeopardy? And the court, in a 6-3 decision, said no, it didn't violate double jeopardy, because the prosecution under tribal law was by a separate sovereign, or at least was under the law of a separate sovereign than the federal prosecution. So again, reminding us all that tribal sovereignty is legitimate and predates federal sovereignty and is separate from federal sovereignty. So some good decisions there that support tribal authority to work in this area, with the full support of the federal government. I think these issues, there's some issues here to watch. I think this is where there's going to be development in this area. One is, we've not had the Supreme Court actually review a case where a tribe has exercised criminal jurisdiction over non-Indians as far as prosecution under the Violence Against Women reauthorizations. So that's going to come up, and I think a lot of us are anxious to see how the Supreme Court views that. I don't anticipate any problems, but we don't have a whole lot from the Supreme Court on that question. Another one is civil jurisdiction over non-Indians, and tribes have some authority to exercise civil jurisdiction over non-Indians, and the question is how much. And for one way a tribe can exercise civil jurisdiction is in a tort case. And perhaps the most famous case that we've had so far in this regard was regarding the Dollar General Corporation versus Mississippi Band of Choctaw Indians. Here, Dollar General opened a store. You've probably seen Dollar General stores. They're all over rural America. And Dollar General had opened up a store on trust land of the Mississippi Band of Choctaw under a lease with the tribe, and had a program in which they had interns, tribal interns, working in the store. And one young man, a tribal youth, was working as an intern in the Dollar General Corporation store and accused the manager of the Dollar General Corporation store of exercising inappropriate actions towards him. And the young man and his parents sued Dollar General, but they sued in the Mississippi Band of Choctaw Indians court. And Dollar General tried to oppose tribal jurisdiction and said that it was not appropriate. It didn't exist here because they were non-Indians. And the federal courts upheld jurisdiction by the Mississippi Band of Choctaw Indians court against Dollar General Corporation to hear that tort claim about the sexual abuse of a young man at the Dollar General store. And that one went up to the Supreme Court. The Supreme Court took cert in that case, but that was in 2016, and Justice Scalia passed away while the case was before the Supreme Court. And so the Supreme Court was left with 8 members, and they split 4-4 and issued no opinion. So what happens in that case, it's called affirmed by an equally divided court. So whatever the Federal Court of Appeals below had done became affirmed. And the Fifth Circuit had held that the Mississippi Band of Choctaw Indians court had jurisdiction over this case. So it continued. That was back in 2016, and we keep thinking that there will be another case along those lines, because we know that they took up the case, presumably because they wanted to say something about that issue. And so a lot of us in the Indian law space have been thinking, well, there's going to be another case eventually, but we haven't seen that yet. One of the things, this is an area of dispute because state courts, states, I think, would like to see cases like this proceeding in their own courts. And, we've developed tribes. Another thing that's happened in the last 50 years is a lot of tribal courts have really have been developed and have become much more active in resolving disputes on their reservations. So we anticipate that this may be an issue that will come up before the Supreme Court. There actually was a case. This is the test that's used. It's called the Montana test. It's been around since 1981, but it's the test that determines whether a tribe can exercise jurisdiction over non-Indians. The general rule is no, a tribe cannot exercise jurisdiction over non-Indians, but there are 2 key exceptions that are explained in yellow here in this quotation from the Montana case. And one case we thought would raise this issue. Again, we thought the Dollar General would, with its 13-year-old child tort case, but we've kind of seen some other cases come up on cert petition, and we thought they might be accepted. There were 2 cases in the last term that we thought would be accepted that were not. They were denied cert, but I'll just give you the facts because they'll give you a sense of how this kind of thing comes up. In the last 20 years or so, there's been an insurance company called the Lexington Insurance Company that sells insurance to tribes to protect them for their gaming operations and that sort of thing. And the business line by Lexington Insurance was called Tribal First. They purposely marketed to Indian country this Tribal First line of insurance. And the insurance are liability policies, but one of the things they include is business interruption insurance. And so Lexington Insurance Company had sold a lot of policies throughout Indian country before COVID. And when COVID came along, tribes said, pay us. We've had a business interruption. We have business interruption provisions in our policy with you, so you need to pay us for our lost income. and Lexington Insurance refused. And in some cases, when that happened, tribes sued Lexington Insurance Company in their own courts. And two of those cases came up in the Ninth Circuit. And the Ninth Circuit, the federal court that covers the West Coast, said that, yeah, the tribal court has jurisdiction. Lexington Insurance entered a consensual, relationship with the tribe by selling them this insurance. And so even though they hadn't actually set foot on the reservation, they'd certainly done business with the tribe. And so the Ninth Circuit held that the tribal courts did have jurisdiction to hear those disputes. Lexington Insurance sought cert in the Supreme Court, and the Supreme Court denied cert. So that may mean that the Supreme Court was okay with that exercise of tribal court jurisdiction, but we can't be sure exactly what it means until the Supreme Court issues another decision. So that's again, that's another thing that we anticipate seeing. From a tribal perspective, here's the good news. There have been about 18 or 19 decisions in the last 10 years before the U.S. Supreme Court, and tribes prevailed in most of them. And so if there is a case accepted cert these days, odds are the tribe is going to prevail. So we don't know what it changes each year, and some of these losses have been significant losses, but there certainly is some tension here, and the tension is driven in part by tribes just exercising much more authority than they ever have before, including especially over non-Indians. And so I think we're going to see more development here. But hopefully it gives you a little bit of a sense of some of the tensions that arise, jurisdictional conflicts when tribes exercise their authority. Tribes sometimes are in tension with the state, sometimes they're just in tension with the non-Indians, but in either case, there's significant, questions about this renaissance in authority being exercised by tribes, and what kind of issues that might cause. So that's kind of what, trying to get across, both what are the impacts, what are the developments when the tribe exercises so much authority, more so than they ever have before. What kind of disruption and dislocation does it cause? And most of those cases are some sort of example of that. By the way, the picture on this slide, I took that picture. That's Chaco Canyon in northwestern New Mexico. That was the time of a previous tribal renaissance. And it's a beautiful area if you've never been there. It's not easy to get there, but it's also reflected a time many hundreds of years ago when there was also a very active tribal culture in that area, and that was a center of culture. So things have changed since the Chaco culture lived. We now have lots of Europeans running around and others running around North America, and this is ideas to kind of understand what does that mean for tribal authority that once was absolutely dominant on this continent. So why don't I stop there and take some questions.
Okay, so we have one question in the queue right now,
Okay.
And it's from Jay Jones. It says, what about tribal governments and ICE? What are the interactions, jurisdictions, and risks?
It's a great question, and we keep opening up our computers and our phones and seeing these stories where Native Americans are being detained by ICE. My wife keeps saying, we got to get out of this country. And I keep saying, honey, we're Native American. Where are we going to go? So that's a real issue. This is an area, there's going to be a lot developed in this area for a number of reasons. One of the interesting things with ICE is, they aren't necessarily wearing uniforms, and they're covering their faces, and they're not always displaying badges. And so one of the things that not just Native Americans, but anybody may have a real question about is this really a law enforcement agent who's giving me orders? FBI has announced that criminals, offenders are claiming to be ICE on some occasions because they can put on a mask and carry a weapon too. And so it's eroding sort of the authority of law enforcement. We can't trust law enforcement quite as well when people without identification, with their faces covered, without being in uniform, are trying to exercise authority. So generally, the answer, though, is if it's a federal entity, a federal agency, generally does have there's a doctrine in the federal law called the doctrine of superior sovereignty, and the federal government is supreme over states and over tribes in law enforcement. ICE is curious because we haven't in years past seen ICE being really exercising their authority very much, except at the borders. And so these interior exercises of authority by ICE throughout the country is quite unusual. And so I think we're going to see more law develop, more cases develop on what's the law when ICE attempts to exercise jurisdiction so aggressively, far beyond the border. So I think that's a real issue, and it's an issue that doesn't just impact tribes. But I think that with tribes exercising law enforcement authority, there is a chance, there is a real risk of conflicts between non-uniformed federal officers and tribal officers I can imagine that happening, and I can't tell how it's going to happen. I think it could happen with state authorities as well. And so it's the aggressive nature of ICE is going to have some real impacts, and probably going to change the law around law enforcement in this country, because I think it's raises some troubling new issues that the courts are going to wrestle with. Why don't I stop there?
I think we have time for just one little question because I think it's really timely, Seth. Excuse me, Professor Davis. Um, the last question is actually involving some new stories coming up regarding the Major Crimes Act, and the case involving U.S. versus CAGMA, whether or not it'll be revisited by the court. It does involve a case involving a California tribe here, the Yurok tribe, and whether or not the court will approach it differently in how it looks at the Major Crimes Act and its applicability. Do you have any thoughts on that?
I will, although our next speaker is probably a better scholar on these issues than I am, more of a con law professor. But I will say this: the question is how broad is Congress's power over Indian tribes, and CAGMA, the famous CAGMA case that upheld the Major Crimes Act. Had a really broad notion of congressional authority, because we call it these days the plenary power over Indian tribes. And Justice Thomas, to his credit, has always been skeptical of broad federal authority, in part, I think, because he wants to protect state authority. He doesn't want federal government authority to encroach on state authority. But the question is, if the federal government is a government of limited enumerated powers, what do we do when the federal government is exercising powers that are far beyond these limited enumerated powers? And the Constitution doesn't say plenary power. It says it includes authority over the tribes in the Commerce Clause, which also includes foreign nations, by the way. So the Commerce Clause power could actually be quite limited, and it may not grant this broad federal authority over tribes. And so the question is, if the plenary power has been exaggerated or overestimated, then where does that leave us? And it might leave us in a place where the Major Crimes Act is unconstitutional. It may mean that other laws are unconstitutional in which the federal government is encroaching on tribal sovereignty. On the other hand, the concern is that, in Justice Thomas's mind, his view also seems to go along with maybe not a lot of legitimacy for tribes. And so he sort of views a world that has the federal government and states as the primary constituents of that world, the federal system. And I'm not sure he sees a strong role for tribes in that system. And so I'm inclined to agree with him that I'm not sure the federal government has as much power over tribes as it has exercised in the past. But to me, the answer then, the solution is that it means that the federal government doesn't have power on Indian reservations, for example. And it certainly means that, states don't have power there either. So federal or tribal power would be exclusive. I'm not sure that's the way Thomas sees this unfolding. I don't know how Gorsuch sees it unfolding. And Gorsuch has exercised much more respect for tribal authority in past cases. So I'm not sure. I think he and Thomas both agree that there's not broad federal authority over tribes. But that's a fascinating issue, and it's going to be interesting to watch. And there are only two of them that are deeply interested in that issue, I think, only two of the 9 justices. So we'll have to see how things shake out. We'll have to wait for an appropriate case that presents the issue in a way that interests the other justices before they take that kind of case up. But it's a fascinating question.